Welcome to This Explainer. Today, we're diving straight into a really fascinating administrative law case. It's one that completely tests the exact boundaries of homeowner association powers against the rights of the individual homeowner. We're going to look at a real-world dispute that asked a pretty huge question. What actually happens when HOA rules physically restrict how you get to your own front door? I want you to picture this. You're coming home from a long day, you finally pull up to the automatic gates of your gated community, and you reach for your electronic transponder just like you always do. But instead of the gates swinging open to welcome you home, nothing happens. Your access has literally just been deactivated. You're suddenly stuck on the outside looking in. So it begs the question, right? Can your HOA legally lock you out of your own neighborhood? I mean, it sounds extreme, but this exact situation is at the very heart of the dispute we're unpacking today. And this isn't just a hypothetical. This exact scenario happened to an Arizona resident named Nathaniel Smith. And while he didn't just complain to his neighbors about it, he actually escalated the whole issue to a formal legal showdown. Everything in our explainer today is based entirely on the official transcripts and legal orders from the Arizona Office of Administrative Hearings. This all went down in early 2026, where the case was argued right in front of an administrative law judge. So let's meet the key players in this legal dispute. On one side, we have our petitioner, Nathaniel Smith. He's actually been a homeowner in this community since 2004. So, he knows the neighborhood incredibly well. And facing off against him is the Respondent, the Anthem Country Club Community Association. Now, to give you some context, this is a massive, dated residential community in Anthem, Arizona. We're talking over 2,800 homes and around 6,500 residents. As we'll see, the access rules they enforce have a massive impact on daily life there. Now, what sparked this whole legal battle? It actually wasn't a noise complaint or, painting a house an unapproved color. It all came down to a delinquent assessment balance of roughly $2,400. According to the case records, this balance started accruing around April of 2024. And because this balance went unpaid, the HOA triggered a very specific collection policy. Basically, they turned off Mr. Smith's electronic gate transponder. Here's exactly how the whole dispute escalated. On October 31st, 2025, the HOA sent Mr. Smith a deactivation notice, basically giving him 10 days to bring his account balance below a $400 threshold. He did make a partial payment, but it wasn't enough to satisfy that requirement. So boom, his transponder was deactivated. In response, in December of 2025, Mr. Smith fired back and filed a formal petition with the Arizona Department of Real Estate. This escalated the whole matter to an official hearing in April 2026, which ultimately culminated in a final verdict in May of 2026. All right, Section 1, the homeowner's argument, focusing specifically on limiting ingress and egress. So Mr. Smith's core argument against this whole transponder deactivation policy really came down to the concept of limiting. He cited a very specific section of the rulebook stating that the board cannot authorize any rule that limits ingress or egress to a lot. At the hearing, Smith testified that by turning off his transponder, he was forced to drive to a manned main gate 3.1 miles away, which added an extra 8 minutes to his commute. He argued, quote, by any practical or standard definition, going from 4 gates to 2 gates and eventually down to 1 gate, it is limiting. To him, cutting off his primary access points was just a blatant, direct violation of the rules. And he made another really interesting point. He contended that the transponder system shouldn't even be classified as a suspendable service in the first place. See, the HOA claimed they could suspend services for non-payment, but Smith pointed out that the gate hardware and the transponder readers, well, they're essential infrastructure. They're paid for by the standard homeowner assessments that absolutely everybody pays. So in his view, simply clicking a button on a computer to deactivate his transponder isn't pulling a service. It's actively restricting access to community infrastructure that he literally paid to build and maintain. Moving on to Section 2, the HOA's defense, which they framed as a voluntary service. The Anthem Country Club Community Association, who were represented by their legal counsel and their former community manager, Megan Hill, well, they countered with a fundamentally different interpretation. They argued that transponders are absolutely not a fundamental right tied to homeownership. In fact, their legal counsel pointed out that the word transponder doesn't even appear anywhere in the original CC&Rs. They argued, quote, under the association's governing documents, there is no right to have a transponder. The transponder process is a voluntary process. Basically, when a resident wants a transponder, they have to sign a totally separate agreement. And that agreement explicitly states you must abide by the deactivation policy if you fall behind on your assessments.
So we have a complete clash in perspectives here on what actually constitutes access. While Mr. Smith viewed having his gate options reduced from 4 down to 1 as a clear, undeniable limitation of access, the HOA viewed it entirely differently. They pointed out that Smith was never actually denied physical access to his home. He could always use the 24/7 manned guest gates. Now, yes, he had to wait in the visitor lane and check in with a guard, but the road to his house was literally never closed off to him.
Furthermore, the HOA explained the practical why behind this 12-year-old policy. Look, when homeowners don't pay their assessments, the HOA still has to cover community insurance, maintenance, and utilities, right? If they couldn't deactivate transponders, what are their alternative collection methods? Well, they're pretty severe. Filing a lien against the home, filing a really costly lawsuit, or even pursuing property foreclosure. The HOA argued that disabling a transponder is actually a much gentler, faster, and far more efficient way to get a homeowner's attention and bring them into compliance, all without ruining them financially or dragging them into court.
Which brings us to Section 3, the CC&R Rulebook, and the showdown between Section 7.4 versus Section 11.1.
Ultimately, the administrative law judge had to weigh conflicting clauses within the community's incredibly dense legal rulebook. On one side, Mr. Smith relied heavily on Section 7.4, which strictly states the board cannot limit ingress or egress to a lot. But right next to that, the HOA relied on Section 11.1, which grants the board the right to suspend the right of an owner to use facilities within the common area for any period during which a charge remains delinquent. It's a classic, textbook legal battle of definitions. Is the electronic gate an ingress that absolutely cannot be limited, or is it just a facility whose convenience can be suspended?
And that leads us to Section 4, the final verdict, handed down on May 4th, 2026.
After carefully reviewing the governing documents, the financial statements, and the gate maps, Administrative Law Judge Velva Moses-Thompson officially dismissed Mr. Smith's petition. She determined that the HOA did not unlawfully block his property access. Because the main manned gates were always available 24 hours a day, 7 days a week, and entry through those specific gates does not require a transponder, his fundamental right to access the home remained entirely intact.
In her conclusion, the judge wrote, quote, "Although it may have been inconvenient for Mr. Smith to access his property using a main gate, the ACCA has not limited or blocked Mr. Smith's access to his home or the common areas by deactivating his transponder." So the absolute crucial takeaway here is that in the eyes of administrative law, inconvenience simply does not equal a blockade. A transponder is indeed considered a suspendable service or a facility privilege when community assessments go unpaid. This ruling really reinforces the substantial power that homeowner associations hold to collect debts and enforce compliance. It clearly legally defines the line between essential property access and a revocable community privilege. But, it leaves us with a fascinating and maybe slightly unsettling final thought. If your HOA can legally deactivate your automated neighborhood access over an unpaid fee by just classifying it as a convenience, what other daily comforts and voluntary services in your neighborhood are actually just suspendable privileges? It's definitely something to think about the next time you drive through your neighborhood gates. Thanks so much for joining me on this explainer, and keep learning.